I'm referee Melissa Telling. I am a referee in the 4th Judicial District. I'm assigned to the civil and criminal divisions. I preside over housing, harassment, and petty misdemeanor court trial matters. I have been now the senior referee in housing for the 4th Judicial District for the last year and helping us navigate this new world in the pandemic. So thank you for having me here this afternoon. As Elvira said, please submit questions as I want to make sure that you're getting the information that you want today and not the information, just the information that I think you need. And we'll move through the program. So today we're going to talk about a little bit about the moratoriums, the phase outs, and Zoom, and what the current landscape looks like for landlord tenant actions in Minnesota. In terms of our learning objectives, I wanted to talk about the status of the federal eviction moratorium. When this originally was planned, we actually had federal eviction moratoriums. We'll talk about that in just a moment. Talk about the Minnesota eviction moratorium phase out, some new notice requirements for local municipalities, common housing court actions initiated both by landlords and tenants, the future of virtual court, and then some resources as you might want to guide individuals that you're helping with. So in terms of the federal eviction moratorium, we have had 2 different types of moratoriums over the last year and a half. One was first enacted by the CARES Act, and it began on March 27th, 2020. It ended on July 24th, 2020. And that essentially created a 30-day notice period and prevented evictions for covered tenants until August 23rd, 2020. That is now expired. And so it only applied to federally related properties, and it doesn't apply any longer. Another federal moratorium that was in place a bit longer was the federal moratorium that was initiated by the CDC. That particular moratorium went into effect on September 4th, 2020, and was extended 3 times, ultimately expiring late in August when the Supreme Court issued a decision finding that Congress and not the CDC was authorized to take such action to place moratoriums on evictions. The CDC order applied to all renters, not just those in federally related properties. And those renters had to attest that they met certain income and other eligibility criteria. Both applied only to non-payment of rent cases and related fee cases. So the Minnesota moratorium throughout this period of time has been more restrictive and therefore is really the moratorium that has applied to evictions readily here in Minnesota. Neither of these federal eviction moratoriums are in place anymore, and so we don't really have to worry about it, but it were interesting when they were in place and created a lot of conversation. So the eviction moratorium in Minnesota was put into place last March. So March 2020 is when the original executive orders went into effect related to placing suspension on certain types of eviction actions in Minnesota. And throughout the last year, those executive orders have been modified, changing sort of the types of evictions that could be filed, timelines related to those evictions, and requirements for landlords and tenants. In June of 2021, the legislature passed the eviction moratorium phase out, which is found at Minnesota Session Laws 2021 First Special Session, Chapter 8, House File Number 4, Article 5, which is long name that we don't have a statute that we can just refer to, but we typically just refer to it as the phase out. It went into effect June 30th, and it essentially made any of the executive orders that had previously been issued null and void. So it replaced the moratorium with this gradual reintroduction of evictions in Minnesota. What it does is it creates a timeline to allow those evictions to be filed, hopefully at a pace that allows the courts to keep up and allows for tenants to take whatever actions they might need to protect their tenancy. So what does the eviction moratorium phase out do? It does create a new notice provision for non-payment of rent cases. And what needs to happen is that landlord must provide a 15-day pre-filing notice to tenants. And that notice must include that the eviction moratorium has ended and the tenant may soon be subject to an eviction. The landlord needs to provide the tenant with the total amount of rent that is due, and then explain to the tenant that they should visit Rent Help MN or call 211 to see if they are eligible for financial assistance. As of September 12th, 2021, in addition to certain non-payment of rent cases being heard, landlords can also file evictions for lease terminations if the tenant has seriously endangered the safety of others, if the tenant significantly damages the landlord's property or the curtilage, if the tenant violates 504B.171, subdivision 1, which we typically refer to as the illegal activity covenants, where both landlords and tenants covenant that there will not be illegal activity on the premises, or if there are material lease violations other than non-payment of rent. Those are the types of lease terminations or general eviction actions that can be filed as of September 12th. Now, that doesn't preclude non-payment of rent cases. However, the non-payment of rent cases that can currently be filed need to meet certain requirements. So one of those requirements is if the tenant is eligible for I wrote COVID-10, but it's COVID-19 rental assistance, and refuses to apply or refuses to give the landlord information so that the landlord can apply, or refuses to provide proof that they've applied. If the landlord can attest that, yes, the tenant is eligible and that they've refused, then the non-payment of rent case can move forward, or if the tenant is ineligible for assistance. In either of these types of non-payment cases, there does need to be a 15-day notice provided. And the legislature has said that that notice just needs to substantially comply with the law. It doesn't have to be strict compliance. So sometimes what I've been seeing in court is there's a number of communications that have gone between the landlord and the tenant, and if you piece them all together, it includes all of the provisions related to the moratorium ending, guiding the tenant to the rental assistance programs and the amount of rent due. The court also has the ability to stay the action if the 15-day notice was not properly provided. We don't necessarily have to dismiss the case. We can stay it, allow the landlord to provide that 15-day notice and reschedule it for another hearing. Most of the phase-out protections will end October 12th. So in just a couple of weeks, we will be back to business somewhat as usual. However, the phase-out does continue to apply for eligible tenants in non-payment cases until June 1st, 2022, if there is a pending application. So one of the things that's become interesting during this period of time since the legislature passed the phase-out legislation is related to what is eligibility and what does that mean? So I've titled this the Rental Assistance Eligibility Quagmire. What does it mean to be ineligible? So COVID-19 rental assistance is administered mainly by Rent Help MN. However, there are other programs available, including the Zero Balance Project, which occurs in Dakota, Hennepin, and Ramsey counties. And we don't have really good answers to necessarily what it means to be ineligible or how long it takes for someone to become ineligible if they've applied and they were once eligible. As of September 19th, Rent Help MN and Minnesota Housing had finalized a pending application notification letter. So prior to September 19th, there was a lot of question as to how do landlords know that their tenants have a pending application? How do tenants provide proof to the landlord that they've applied? Some applications are by paper, and there's nothing that the tenant gets back necessarily once they send that paperwork in. I think if someone applies online, they maybe get an email back indicating that they've applied. But there was really this question mark of how do we know if a person has applied, whether they're eligible, whether they're ineligible. There are still timelines that are being defined in terms of how application timing is being processed and when people are getting their notifications as to whether they're eligible or ineligible. Not only that, but an applicant can reapply if they've been declined or deemed ineligible until they exhaust their benefits, or if they have new information to provide on their application. So tenants, if they are eligible and they apply, they are eligible for up to 15 to 18 months of rental payments. In addition to that, the application process is actually quite onerous and requires a lot of cooperation between the landlord and the tenant. A lot of paperwork needs to be provided. And so it's not the easiest way to access money. However, there's a lot of money to be accessed. There are currently no limits on the number of times that a tenant can reapply if they've been non-responsive. So if they've applied and Rent Help MN gets back to them and says, we need, this paperwork or that paperwork, and they don't get back to them, and then they're deemed ineligible, the tenant could reapply if they were found ineligible just based on non-responsiveness. Not only that, but once a determination has been made on their application, an applicant can appeal that particular determination, and the timelines for appeals are varying as well. So what does this all mean when it comes to the court? Well, what this means is that the legislation has instructed the court that we are to stay any actions with a pending application, and those matters need to be stayed until there's a final determination, or until June 1st, 2022. So because the status of an applicant can sort of fluctuate, we are staying quite a few cases based on non-payment of rent if there's a pending application. And I think that most likely they will remain stayed until that June 1st, 2022 deadline occurs, because people can reapply. And so they can be pending frequently over the next few months. All right, so in terms of other law changes that have taken place, a number of local municipalities have passed ordinances requiring pre-filing notices in eviction cases. There's probably more cities that have done this, but at least for my purposes, the two that I mostly pay attention to in my job in Hennepin County are the ordinances that were passed in Minneapolis and St. Louis Park. The Minneapolis ordinance requires a 14-day notice before bringing an eviction action for non-payment of rent or other unpaid financial obligations, and St. Louis Park requires a 7-day notice before bringing a similar action. Both cities require that the notices include the total amount due, a specific accounting of what those amounts are. So what amounts are for rent, what are late fees, what are costs, what's interest. Additionally, the notice needs to include the name and address of a person authorized to receive rent and fees, provide a description of how to access legal and financial assistance through the city's website. And at least for the purposes of Minneapolis, the notice needs to be delivered personally or by first-class mail. St. Louis Park also requires that. However, if the tenant and landlord agree in writing that an email notice may be sent for a non-payment of rent case, then this particular notice can be sent via email. The city of St. Paul also introduced some tenant protection ordinances last year called the Just Cause Ordinance. That particular ordinance I'm not addressing today because it's currently enjoined by a federal court, and we'll see what happens with that particular set of ordinances in St. Paul. But essentially what these ordinances do is they set up another procedural step for landlords to take before they can file an eviction action, because under Minnesota statutory law, there is no pre-filing notice requirement aside from the phase-out legislation. So landlords can file their eviction actions immediately upon a breach or upon the non-payment occurring in normal times. So with all that being said, what remains the same? Many things remain the same. The phase-out legislation just changes things for a short period of time, as did the moratoriums. But in terms of what remains the same, and that I really encourage attorneys as well as self-represented litigants to investigate if they're going to appear in housing court, if you're going to bring an eviction action, is making sure that you are reviewing the rules and the laws that apply to eviction actions. So the housing court rules in Hennepin and Ramsey counties remain the same. You can find those at the Minnesota Rules of General Practice 601 through 612. And I do have to say, procedurally, there are a lot of procedural requirements for eviction actions. Whether you're self-represented or whether you're an attorney, it's really important that you're reviewing the rules that apply to residential eviction actions for the general rules of practice, or for commercial eviction actions if you're going to be representing commercial tenants. The other thing that remains the same is the applicability of the general housing court and eviction statute, which is found at 504B, the rules of civil procedure, and the rules of evidence, all of which apply to housing court. I should say that the rules of general practice are specific to residential eviction actions. So if you are representing tenants in commercial actions, foreclosures, or a general civil case that's covered by 504B, that wouldn't necessarily be ruled by the housing court rules. The other thing that has remained the same, and the reason I touch on this is because over the last year, I think when we've had a reduction in the number of eviction actions, people sort of forgot how to do the things that we used to do on a regular basis. But one of those things is going to be the strict compliance requirements for service. So the court in Koski versus Johnson said that for service in a residential eviction action, a landlord must strictly comply with how you're going to effectuate service. And that still applies today. And so you need to make sure that you're following the service requirements and the filing of the affidavits that are required under the service requirements. We also still have the fast timeline for evictions once an eviction action is filed. So once an eviction action is filed, a hearing is going to be held within 7 to 14 days. At least in Hennepin County, that's closer to 14 days just because of our volume and our ability to handle the volume. In other jurisdictions, it might be closer to the 7 days if there is availability on calendars. And then the general causes of action for landlords and tenants has also remained the same. So we're thinking about what those general causes of action are. I sort of put cases into two categories in my mind. I have landlord initiated actions, and that's typically to determine the possession of the property. And then I have tenant initiated actions, and those are typically related to problems with the property. So in terms of landlord initiated actions, there are only a handful of types of possessory cases that we hear in housing court. The non-payment of rent cases, which we've talked about, breach of a material provision of the lease. So if a landlord and a tenant have a written or oral agreement with one another and can establish what the terms of that agreement are, if a provision is found to be material and the tenant breaches that provision, the landlord can recover possession of the property. Third, if the tenant holds over past the end of a lease or the tenancy, a landlord could bring an action to recover the premises. And what's important here is that notice has to be proper under either the statute if it's an at-will tenancy, or it has to be pursuant to the terms of the lease if there is a lease agreement in place for how long notice should be provided. And it should be provided in writing. We hear cases related to holding over past the end of a foreclosure redemption period. And so if a homeowner is subject to foreclosure and they fail to vacate at the end of their redemption period, we'll hear an eviction action related to that. Tenants who are in a foreclosed home have additional protections as it relates to notice and how the owner of the property needs to proceed with the eviction action. And then one of the things that we saw most frequently during the eviction moratorium were violations of Minnesota Statute 504B.171. Those are the covenants not to commit unlawful activity. So that's going to include the use or possession of drugs, the illegal possession of a firearm. So it's not just the possession of a firearm, but it has to be the illegal possession of a firearm, prostitution occurring at the property, harboring stolen goods or property on the premises. And then if there's acts of harassment that are taking place, that also can be a basis under 504B.171. But we became very familiar with this particular provision of the law during the eviction moratorium because it was one of what seemed to be the most convenient and easiest for landlords to proceed under. I think one of the things that was somewhat difficult for people was particularly related to the drug provision of 504B.171 and the use or possession of marijuana. Because of the status of marijuana throughout the country, in some places being legal, here of course being illegal, whether that should truly be a violation of 504B.171. I believe that judicial officers across the state all had the same position that in Minnesota it is illegal, so that that would be a violation of 504B.171. But I think it was one of the more difficult reasons to exclude someone from the property if it was just strictly a marijuana violation. So one of the new things that I've kind of added to my presentation is what happens once the court rules. So I think oftentimes what gets forgotten or we become remiss to explain is you come before us, you filed your eviction action, we've ruled on your eviction action. Well, now what happens? We either issue our decision on the record or you get our decision in the mail. But I think it's important to know what happens next, because it's not a magical, we rule in your favor for the writ of recovery to issue and then poof, the tenant has suddenly vacated. But there are additional steps that have to take place. And for each county, the overall process times might differ a little bit. And if you have questions about how the timelines are going to work in your county, I really encourage you to talk to your court administrator about how eviction cases are handled, because each county is going to handle them probably a little bit differently. And the court administration always seems to know the best answers to some of these questions. But essentially, once a decision is made, the order gets mailed or served via e-file and serve. Once you get that, particularly in an eviction action, that's not the end of where things go. If the court has ordered that the plaintiff can recover the premises and that a writ of recovery can issue, you have to then request that writ and pay the fee to the court administrator. We will then issue the writ of recovery dependent on whatever the order said. So if the writ of recovery was going to be stayed for a period of time to allow for the tenant to vacate between the time of our order and when the writ might issue, we'll issue the writ when the stay expires. And then once the fee is paid and we've issued the writ, you will then take that to the sheriff of your county, and the sheriff will serve that on the property. Sheriff serves it on the property by posting it on the front of the property for at least 24 hours. So a tenant would have 24 hours to vacate after the posting, or until the sheriff returns with the plaintiff to remove the tenant. So I know that in Hennepin County, it's not 24 hours. It is a longer period of time than that, just because of the sheriff's department tends to be busy and executing writs or removing people from the property is not the most pressing issue that they have to deal with. So it's not necessarily a priority unless we have issued a priority writ, which we can do if there is some sort of nuisance or serious violation occurring at the property. And then the thing to remember is that if you are a landlord, you are required to store personal property according to the statute for the tenants if they do leave personal property behind. So then in terms of tenant-initiated actions, there's also a handful of those. Probably in the last few months, I've seen more lockouts than I typically see in any given year. I think part of that is due to some frustration that's been experienced by landlords during the eviction moratorium, where they haven't been able to remove what they consider to be problematic tenants. And so they're taking some action into their own hands, which is not permissible under Minnesota law. And so if a landlord does change the locks or change a code or disables a key fob, that would be considered a lockout. But there's also lockouts that occur that are a little less obvious. It might be landlords who remove a window or a door, or landlords who shut off a utility. And those also can be considered lockouts under Minnesota statute 504B.375. But we have been seeing more lockouts filed recently, at least in Hennepin County, because landlords, I think, are frustrated with the moratoriums. Rent escrow actions are another type of tenant-initiated action. For a rent escrow action, those are going to be initiated if there is some sort of violation at the property, whether that be a repair issue that's been noticed by the tenant, or if a local authority has come in and issued a order to repair the rental property. If the tenant indicates that there is a repair issue, the tenant does need to send a notice to the landlord at least 14 days before filing the rent escrow action with the court to allow the landlord an opportunity to complete the repair. And then the tenant can file with the court the rent escrow action and deposit any rent that might be due and owing at that time with the court, for the court to hold in escrow until we have a hearing and a determination on the repair issue. There's also emergency tenant remedies actions, and those particular actions, again, are an emergency basis. So essentially, it's a loss of some sort of critical equipment or critical utility at the property. The tenant needs to provide the landlord 24 hours notice before they file the emergency tenant remedies action. But this is often times where water has been shut off, the sewage is backing up, or it's not functioning. Sometimes we will have ETRAs filed for stoves not working or refrigerators not working. But the landlord does have, that 24 hours to complete the repair. The court can order relief on emergency tenant remedies actions without necessarily having a hearing in the matter. But if we are going to order that relief, it really is important that the landlord truly has not responded, not just that the landlord has responded in a way that the tenant doesn't like. So oftentimes a tenant will have one solution to a problem, but there might be 4 or 5 different ways to solve the problem, and the landlord chooses A, but the tenant would prefer the landlord had done D. We have to sort of look at those in terms of, did it solve the emergency? And then if there's sort of what I would consider bigger issues that are sort of ongoing and long-term and truly affect the property in a significant way that's just not been attended to by the landlord, a tenant can file a tenant remedies action, and those can also be filed by a neighborhood organization or a tenant organization with certain constraints. But those are all of the different types of tenant-initiated actions that we typically see in housing court. And then tenants do have some opportunity, if there has been an eviction judgment against them or an eviction action against them, to take some steps after that eviction to find some relief from that record existing. And they can do that by filing for a request for expungement. There's 2 different legal theories that the court can grant expungements of eviction records based on our discretion and our inherent authority, or based on the statute, which is found at Minnesota Statute 484.014 and 504B.375. Now, expungement of eviction actions can be critical for tenants in terms of them finding future housing. The way that eviction filings work is that once an eviction is filed, it becomes part of the public record, and essentially it is placed on the tenant's rental record immediately upon filing, regardless of the outcome. So even if the disposition of the case was in favor of the tenant, that record still can appear on a tenant's rental history. And if a landlord is requesting background information on a tenant for future housing, most of the time, all that they will see when they get some sort of report from a tenant screening agency is that there's been an eviction filed, but it won't provide any information about the ultimate outcome. And so if a landlord sees, oh, there's been an eviction, that might be enough for them to determine that that tenant is not a tenant that they would like to offer a rental unit to, even if the outcome was in the tenant's favor. So expungements can be a useful tool for tenants to clear their record in the future. We also now allow for parties to agree to certain terms related to expungement at the time of a settlement agreement in an eviction case. So oftentimes, if parties are negotiating a settlement, the landlord will indicate that if the tenant does what the landlord is asking them to do as part of the settlement agreement and they comply with those terms, then one party or the other will file what we're calling an affidavit of compliance with the court, and we will expunge the record administratively without there needing to be a motion filed, which allows sort of the tenant to have a little carrot to follow through with whatever the agreement is, and it doesn't necessarily feel as coercive as it can at times when people are negotiating those agreements as it relates to housing. So I will have Elvira send out my slides after the presentation today, but what I put together here is sort of a chart that's a quick referral chart for you if you are going to be representing tenants. I didn't do this for eviction actions because essentially the timelines for evictions are the same regardless of what type of claim you're making in your eviction action. So tenant actions are a little bit different because each one requires service to take place in a slightly different way. Each one requires notice before an action is filed in different ways. And then there's some hearing differences that exist for each one. And I won't read this whole thing. I will trust that if you are interested, you can read it once you receive it. But this will be a good quick reference in the future. So moving on to the future of virtual court, or the life of court in the Zoom world. People always ask, what is the status of virtual court? And at least now, for the foreseeable future, housing court matters will continue to be held remotely. This can be both good and bad. It has advantages for those who have transportation or time constraints, but it also can create some barriers as it relates to technology. Not everyone, has a smartphone. Not everyone actually knows where the star is located when you ask people to unmute by pressing *6. It sometimes takes time to figure out where is your number keypad, right? I mean, if we all had flip phones, finding the star might be quite simple, but with smartphones, it can be difficult to get back to your number keypad and find that star. So while virtual court has been great in terms of reducing the number of defaults that we have, people tend to be able to appear more easily. It can be difficult for people who have technology barriers. So because of that, I really, really encourage lawyers and practitioners to become proficient in the technology that we're using in the courtroom. It would be the same as if you needed to learn how to go through weapons screening or needed to learn how to write a brief. Practicing and learning how to use the virtual technology that we're using now is really important. And practicing that with your clients or your staff can be equally as important. If you think about it, coming to court in and of itself can be scary. And then you add another level of uncertainty as it relates to what if my technology fails? That just creates more anxiety than even just having the underlying case in place might in and of itself. So you can practice muting and unmuting, how that particular task works, instructing clients as to where the star is located, that it's *6. Maybe create a little cheat sheet for them to have in front of them because it's easy to forget what number you have to pick. If use a variety of different types of technology when you're teaching yourself. So at least for the court, what we've done so that we can better help litigants and parties that are appearing before us is we've pulled out our own personal cell phones, whether that's an iOS device or an Android. We've used Mac computers, we've used PCs, all to try to figure out how does this look to people who are using the technology so that we can more easily guide them if there is a technology issue. And it's a great way for you to help your clients feel more comfortable at that first virtual hearing if you've practiced on your own. It's also really great for you to practice on different devices because if your own computer fails and you need to grab your smartphone, it will then cause hopefully less anxiety for you if you're like, oh yeah, I've done this on my smartphone before, I've got this. So practice on a variety of different devices. Practice using breakout rooms. So one of the things that we use quite heavily in housing court in the fourth are the breakout rooms. And so we're always moving people in and out of breakout rooms, asking people to be able to leave them, practicing that on your own, practicing that with your clients, the difference between leaving a meeting and leaving a breakout room, those sorts of things can be very useful. The other thing that's tricky is if you're using a phone, it requires you to connect the audio in the app. And sometimes people forget to do that. And so we can see your picture on the screen, but we can't hear you, and you might not be able to hear us. And so practicing how to get that audio connected can be really useful. In addition to that, when you are signing on to virtual hearings, both for if you are an attorney, if you're self-represented, make sure that you have a name on your screen that clearly represents who you are. Granted, you may have signed in to something else the night before. Maybe it was a happy hour or some sort of reunion and you were using some funny name, and that might be what automatically appears. But if you can rename yourself as quickly as possible, that's really helpful to the clerks when they're calling roll. And it's helpful for the court to know who is present. It's difficult to do that on your phone if you're dialing in, because you'll just have a phone number there and there's no way to rename yourself. But we try to get you renamed so that we at least can identify what the black box is and who's represented by that black box. But put your name, first and last name. If you're there as an attorney and you're representing a party, put that party's name on there. That helps us coordinate who's there, who should be going into what rooms, and who's ready to be heard. And then in terms of if you're going to continue in the virtual courtroom for a hearing, an evidentiary hearing or a trial, most judicial officers, I think now, are issuing orders that instruct parties, how you should submit exhibits in advance, how you should be labeling exhibits. But it's very useful if you can pre-label your exhibits, if you can have them organized for the court when you send them in. And of course, contacting either the court administrator or the law clerks for the judicial officers to find out any preferences is always welcome, to make sure that things are moving smoothly. So one of the things that's been really helpful during the eviction moratoriums and sort of the slowdown on evictions is allowing different organizations to get up to speed on how to help people who are working through the process, whether they're landlords or tenants. So this particular page just provides you with some information about where you can guide people for assistance, whether that be legal assistance or financial assistance. and any questions that they might have as to how to proceed. I will say that, you know, the phase out, while when you're working with it on a daily basis, is not that complicated. If it's an eviction action that you're only bringing every now and then, and you haven't done one in a year or two, and this is all new to you, phase out legislation is pretty complicated. The notice requirements have become more complicated. Service requirements have become more complicated. And so contacting one of these organizations to help guide you in terms of how to proceed can be really useful. So I realize that went really quickly. So hopefully we have questions to fill in more time, because I do want to answer the things that you want to hear about. So you can get to questions here. Someone asked, what are the prevailing interest rates? I'm going to guess that that means, or the question is, what is the interest rate on unpaid rent? And I don't know the answer to that question. That would probably be a good question for a conciliation court referee who deals more with the collection of rent itself. But I believe, and I'm not even gonna guess. So I'm not sure what the answer to that question is. And then someone asked, is there a checklist available outside the application itself to assist in gathering the required rent help information and documents? Yes. If you go to Rent Help MN, they actually have a checklist for tenants, and they have a checklist for landlords. So that is a great way for you to gather the information that you might need prior to submitting an application, or as the application is moving through the process, sort of checking off what's already been provided. People have other questions? If not, I'll let
You can
you
certainly give it a minute just to see. I think sometimes it takes people a second to get the questions in.
Don't be shy. This is your chance. Anything you wanted to know about housing court?
Okay.
One of the questions is if I could talk a little bit more about what we expect when the next phase of the moratorium ends, if we're expecting an onslaught of new cases. You know, that's a really good question. The courts are preparing for an onslaught of new cases. I will say that we are preparing for a large influx of cases based on non-payment of rent. We're hopeful that that's not the reality, and that people have accessed the financial resources that they might need, and that tenants have continued to pay their rent throughout the period of the moratorium, so that really we don't see anything greater than what existed prior to the moratoriums going into place, which is more than what we are currently seeing. So before the moratoriums went into place, at least in Hennepin County, we were hearing around 500 initial appearances a month. Over the last few months, as the phase out has come into effect, we've sort of gone from, you know, maybe 40 cases during the moratorium to 100. And now I think this month, right now, we're at about 160. So the phasing back in is definitely helping in terms of allowing us to slowly ramp up. And we're hopeful that there's not going to be a huge onslaught, and that people have been able to pay their rent throughout the moratorium. But we are prepared to handle a larger number of cases initially, if that's what happens in October. We all really do wish we had a crystal ball so that we could really know what our lives are going to look like in October. But at least for now, we're just gradually adding calendars as filings dictate. Someone said, under the phase-out legislation, evictions for non-payment of rent are barred when there is a pending application for rental assistance. Can a tenant be evicted for other reasons, i.e. material lease violations, property damage, etc., even if there is a pending assistance application? The statutory language is somewhat ambiguous. Yes. If there is a separate basis for an eviction, that could take place now. So even pre-pandemic times, the statute is set up so that you can claim alternative grounds for possession of the property. So you can claim that there's been a breach and you can claim that there's been non-payment. Essentially, in the past, what we've had to do is we've bifurcated those particular trials so that we handle the breach claims first, and then we would handle the non-payment. In housing court, you're not getting a judgment for an amount of money that is unpaid. So really, when you have a non-payment case, we're just determining was rent paid or was it not necessarily the amount that was due, unless we're issuing a redemption order, at which point then we'd have to determine a specific amount. So yes, the answer is you can proceed with a breach case even if there is a pending application. Another question is there a template notice available for landlords that meets the next phase requirement for non-payment cases? For example, the rent help, contact information, etc. Yes, there is. And I wish I were remembering right now what website gives that to you. I believe Homeline has that information available. They gave a CLE, I want to say 2 or 3 weeks ago, where someone from a housing organization provided a copy of that letter, and I believe Homeline put it on their website. So that is where I would check first. Or if you called Homeline, they should guide you to where that letter, that sort of form letter is. And then a question was, how do security deposits work in regard to the specific accounting notice requirement? So as it relates to the specific accounting notice requirement, that would be strictly related to whatever has been unpaid in terms of the obligations for the tenant. So my answer is it depends, which is a classic answer. But if you've entered into a lease agreement with a tenant and it's required them to pay a security deposit and they've not paid the entire security deposit, and that's the basis for the breach, that is different than a non-payment case where you've indicated that you've agreed to pay $1,000 a month, but the tenant has either failed to pay that $1,000 or has only paid portions of it, and there's a non-waiver clause in the lease that says you can bring an action if partial payments have been made. So the security deposits are sort of separate because those are more along the lines of a breach claim. A non-payment of rent claim is related to rent. And so what we would be looking for in the notice required to the accounting is what I would encourage landlords to do, whether there's the accounting requirement or not, is that you have some sort of system set up where every month you're invoicing an amount due, you're keeping track of how much is paid, when that amount is paid, and then when a late fee is assessed or how interest is accumulating if you have something in your rental agreement that allows for interest to accrue, but that you have some sort of accounting program that's keeping track of all of that for you, because that's going to be the easiest way at, whenever you've reached the end of your willingness to be flexible about rent and wanting to bring an eviction action, you can just print that information out and say the tenant received this information every month that they owed $1,000, they paid $800 last month, they still owe $200, now they owe another $1,000, so it's $1,200. You're just keeping track of that on an ongoing basis, and it's not a huge task for you to undergo when you finally want to bring that eviction action. Do landlords have to complete the moratorium 15-day notice each time they want to evict for non-payment? Example, landlord gives notice, then tenant gets rental assistance, tenant fails to pay rent down the road, is the 15-day notice required again? Yes, the 15-day notice would be required anytime the information in that notice would change, right? So one of the requirements in the notice is that you tell them the amount that is due. So presumably, if they received rental assistance and it paid off their balance that was due, they were then starting from a clean slate once that was paid. And each time after that, that they maybe made a partial payment or missed a payment, that would be a new occurrence of non-payment, and therefore a new 15-day notice would be required. Now, only one 15-day notice is required per eviction filing, but because things change between eviction filings or between times payments might be made, I would say that you should give a new 15-day notice each time you're anticipating an eviction action being filed. All right, I think that is all of the questions at this point. I do want to thank everyone for attending today, for wanting to learn more about housing court, about both landlord and tenant initiated actions, and where we're at with moratoriums and new legislation for different municipalities. So thank you for having me. I appreciate it, and have a great afternoon.
And I will post on the website the recording of today's presentation and a link to a PDF version of the slides. And that should happen either later today or early tomorrow morning. Thank you so much, Referee Hoteling.
You are welcome. Thank you for having me.
Yeah.
Sorry we were a little short.
That was really good. I do have a question that I didn't want to put in the chat because I don't know if this is even something that you think about or consider, but we have had the question at our reference desk from landlords of what options they might have when their renter who is severely past due in paying rent because of the moratorium simply refuses to get assistance through Rent Help MN and moves out, and they have no way of contacting them. I just don't know. Essentially, the person was asking, can I apply for help through? And I think it's no, they have to be a renter to apply.
So for Rent Help MN, you do have to be a renter to apply, but if they're in Dakota, Hennepin, or Ramsey counties, the Zero Balance Project is what allows landlords to apply.
Okay, thank you.
Yeah, so in those 3 counties, the Zero Balance Project exists, and that's for landlords. But if they're in an outstate county, it has to be the tenant.
Okay, yeah, thank you for that.
Yeah. All right.
All right. Well, again, thanks so much. I really appreciate it. And I hope you'll do it again for us again in a couple of years. Maybe not the same topic, hopefully.
Well, and maybe the law will change by then. I mean, it's a moving target these days. So,
and who knows what you'll be doing then too. So,
right.
Yeah. All right.
All right. Thanks so much.
I'm going to close it.
Okay. Bye-bye.